My name's Jon Faulds. I'm a lawyer with the law firm Field here in Edmonton, and I, along with Sandra Anderson, represented Leilani Muir in the case which she brought against the Alberta government and which went to trial in the 1990s, and which resulted in a finding that she had been unlawfully and wrongfully sterilized by the Alberta government. I have a dim recollection that I knew something about the existence of the Act in the late 1960s, or maybe 1970, 71. I was working as a junior reporter at the Edmonton Journal at that time, and I have some recollection of there having been some news coverage about people who had been sterilized in the previous couple of decades, and that there was some sort of a little bit of a public controversy about it and about how that could have happened. Not a huge amount, certainly nothing like the kind of attention that resulted, 30 years later, but there was, I have that sense that it was something I knew a little bit about. I suspect that was more because of just where I happened to be located, the kind of job that I was in. Although there was, interestingly, an episode or a piece on As It Happens back in about 1970, in which one of the doctors who saw Leilani Muir at the university hospital when she was in the process of trying to find out why she couldn't have children, was interviewed and described this phenomenon that he had seen as a doctor at that hospital of encountering a number of young women who had come to him seeking information about their ability to have children. All of them having a very similar story of having been in this institution in Red Deer in the previous decade, and from that, the doctor concluded that something had been going on in that institution that shouldn't have been occurring, because he said we had this not quite a stream, but a number of people who had this experience, and who there was absolutely no reason apparent to him why they should have undergone that kind of treatment. Well, he was talking about the Provincial Training School. What was then the Provincial Training School then became Michener Centre, and still exists as Michener Centre today. I think it was one of the most profoundly misguided pieces of legislation that you could possibly imagine. It was wrong in its conception, it was wrong in its execution, the premises it was based on were wrong, and it failed to treat people as human beings. So I think its repeal was ultimately inevitable. Whether it would have happened when it did is given a few changes in circumstances is open to debate. It could have lasted another 5 or 10 years, I suspect, but I think it couldn't have survived any longer than that. I think because there was such a growing awareness all around North America that these kinds of measures were inconsistent with the much greater appreciated sense of individual human rights and civil liberties, and I can't see that it could have survived in the context where you saw the onset of human rights commissions, individual rights acts, and so forth, not just here in Alberta, but really throughout North America. Well, more lives would have been harmed. because more people would have been subjected to a sterilization procedure without their consent, which wasn't in their best interests, and the process of continuing to sterilize Albertans would have carried on as it had for 4 decades, and it wasn't a sure thing that it would be repealed at the end of the 1960s, the beginning of the 70s. At that time, there was a major review that was undertaken of mental health services in Alberta by a fellow by the name of Bill Blair, who's a very eminent psychologist. And while he recommended a host of changes to the mental health system, he did not recommend the repeal of the Sexual Sterilization Act. And that was one of the issues when the legislation to repeal it came forward. That became an issue in the legislature, that this major report that had been done just a year or so before had not recommended that. As I recall, Blair was asked if he would provide a statement on whether he would reconsider his views of the act, and he provided the new Conservative government with a statement that, in his judgment, it now would be appropriate to repeal the act, and that helped move it through the legislature. She came to our firm through the Legal Education Action Fund. She had approached a number of lawyers previously about the possibility of bringing a case on her behalf, and they had all said that they did not think that she had a viable claim because what had happened to her had been done in conformity with the laws of the time. She found that very difficult to accept, as you can imagine, and she finally wound up talking to a branch of the Legal Education Action Fund, I believe out on the West Coast, and they referred her to one of the lawyers in our office, Myra Beelby, who's now a judge of the Court of Queen's Bench, and Myra took the case on and pursued it until she was appointed to the bench, at which point other people in the firm had to take on the case, and that ultimately fell to Sandra Anderson and myself. It seemed to me to be a very important case it seemed important from a bunch of different perspectives. It was extremely important to Leilani. It seemed to me that this was the kind of case where somebody had the opportunity to use the legal system to make their own voice heard after having been essentially powerless and mistreated and ignored. It seemed very important to me as an example of the kind of way that the legal system can help somebody balance the scales, and bring to account a powerful force that had treated her unfairly in the past. So it was very important like that. It was very important from a historical point of view that this piece of Alberta history, which I think you're right, was not very widely known or understood, could be brought out into the light and examined, it seemed to me to be extremely important to take it forward, I consider myself very fortunate to be able to play a role in it. I remember sitting in an office one day to review some documents, and I had in front of me a set of the minutes of the Eugenics Board, the board which had approved the sterilization of people like Leilani. And as I read through it, I had this overpowering sense of this is how evil things happen. through purely what appears on its face to be just banal administrative actions. Here is the list of the 40 people who were seen by the board today. Here is the board's decisions about them. Here they are talking about their expense honoraria. Here they are talking about the location of their next meeting. And all the while they're making these, these decisions which are causing immense damage to people's lives. So that just struck me so powerfully, that how the completely unacceptable becomes acceptable just through mundane, ordinary administrative day-to-day activity. The next thing that struck me was I started to notice things in these minutes that didn't seem to have anything to do with the actual business that the board was supposed to be conducting. All of a sudden, they were authorizing procedures which they had no authority or power to authorize. They were ordering that biopsies be taken of people's reproductive organs. They, in some cases, were ordering that reproductive organs be cut off completely. Removal of a woman's ovaries, removal of a woman's ovaries in her uterus, removal of a man's testicles. All things which were, went far beyond what their purpose was. And that became, as we began to look into why those things were happening, that began to show how it really began to show what a slippery slope this kind of activity is. You start doing something which is ill-conceived and harmful to people, and which doesn't really respect them as individuals, and you very gradually, well, not very gradually, actually rather quickly, you start sliding off into thinking, well, if we can do this, we can do these other things too. I mean, we can use them as human guinea pigs. We can use them to test out, various theories that we have about, reproductive capacities and so forth. It was just, it just seemed to be, an almost textbook example of how that happens. I think that once you start treating people as if somehow they're less than fully human, as if somehow they're less than, they're not entitled to respect as human beings, it becomes easy to do more and more things to them, because if somebody isn't fully human, then they don't, then perhaps you think in some way they don't really deserve, to be treated better, and perhaps you think they don't, that they don't suffer or lose anything as a result. I mean, they're less than human. What does it matter? In fact, Margaret Thompson, one of the members of the Eugenics Board, the one who's an eminent geneticist, said at some point in either the pre-trial questioning or in her trial testimony that when challenged about something that had been done that wasn't really justified, her reaction was, yes, but what was lost as a result of doing it? She didn't see that interfering with a person's physical and bodily integrity is a terrible thing to do to them without their consent or agreement, and that applies no matter who you are. That for some reason and I think that kind of typifies the kind of thinking that leads you down the slippery slope. Well, Leilani's case was the first case that went to trial and which examined the legality of the sterilization process that was practiced in Alberta for more than 40 years. It involved challenging actions that had been taken by an administrative board, which on its face was empowered to do the kinds of things that it did, and so it was it appeared in some respects to be an uphill kind of climb, and it ultimately revealed that although there had been this veneer of legality, in fact the board had been acting illegally, outside of the scope of its powers, for improper purposes, and in unauthorized ways. So it was very important, in some ways, to show how administrative, these boards, which affect so many aspects of our lives, can become really rogue, kinds of entities, and start doing things that they shouldn't do, and which wind up harming people very severely. So, leaving aside entirely the question of eugenics, the case exposed something about the operations of the administrative government that was important. It was, as I said earlier, I think hugely important to Leilani to be able to confront the power that had hurt her. It set the stage for, literally hundreds and hundreds of other people to be able to, who had similar experiences or related experiences, to be able to advance claims against the government, and it resulted in the government arriving at a settlement with all of the other people who had been sterilized, who made a claim, which really amounted to an apology, I think. The government could never quite bring itself to say out loud, we're sorry. But I certainly think that its representative, who negotiated the settlement, and that was a former Court of Appeal Justice, Joseph Stratton, came very close in the remarks that he made when the settlement was announced, so in all those ways, I think it was very important, and it also triggered similar kinds of claims in British Columbia, where there was also a eugenics program, although less vigorously enforced than here in Alberta. And it attracted a huge amount of academic interest as well, because of the light it cast on this particular episode of Alberta's history, and the way in which it reflected a government dealing with social programs in an extremely unfortunate way. By the time we had got seriously into Leilani's case, we were aware of the number of people who had been subjected to the sterilization process. So we knew, and the time frame during which it had happened. So we knew that there had to be hundreds, if not thousands, of people who had experiences like that, and the fact that her claim was so public, that she was prepared to go to trial and tell her story in public and in a way that ensured that the world would hear about it, I think really empowered other people to come forward. I think Leilani did a tremendous service to a very large number of people by having the courage to do that. Why was Leilani able to win her case? I've thought about that off and on, ever since that trial occurred, and the thought that I keep coming back to is that there was a kind of a collection of forces, that really that really kind of worked together to bring about the successful outcome in that case. First and foremost of which is that she was a person who was not going to let this go. She had the courage and the determination to take this case to trial and to go through, you know, whatever it took in order to have it heard. I remember when we were preparing her to give her evidence at the trial, telling her that, you know, they don't call it a trial for nothing, and that she was going to be subjected to very, very vigorous cross-examination, that there was going to be no mercy shown. I remember her saying, well, you know, it's just gonna be like boot camp. I'm just gonna work my way through it, you know, I'm just gonna stick to it, do the best I can, and take whatever they throw at me and deal with it as best I can. And in the end, you know, the fact that the lawyers representing the government did give her such a hard time really worked in her favor, because what better proof do you have of the fact that, you know, here's somebody who, you know, 20 years ago you sterilized them because you said they're mentally defective. Today you're cross-examining the hell out of them, you know, because and you're not treating them with any deference, you know, as if they're somebody who has some kind of issue or disability or anything like that, you know. In a sense, that trial was the first time that the government treated her as a full human being. And, you know, it worked to her advantage. But so Leilani's personality and was a very huge factor in being able to succeed in the trial. But she had support in a lot of different quarters. Dave King, who was one of the former cabinet ministers in the Lougheed era, whose government repealed the Sexual Sterilization Act, was a very large supporter of her. Tim Christian, who was dean of the law faculty here at the University of Alberta at one time, and who had done an early study on the operation of the Eugenics Board, and who maintained an interest in this, and was a large supporter of her. There was this kind of sort of a groundswell of support. So I think her case succeeded because of her. I think it succeeded because of the support and the collection of these forces, and it succeeded because she was right in law. They had mistreated her. The wrongful confinement aspect of the claim was a critical element, and it was more difficult than the sterilization part of the case, because there was less of this, you know, huge, massive documentation and material which showed how badly wrong the Eugenics Board had gone. It depended more on being able to demonstrate that when she was placed in this institution in Red Deer, the Provincial Training School, in the 1950s, that no proper assessment had been done, no proper evaluation was carried out to determine whether or not she should be there, that part of the case was helped by a couple of things. One of them was Leilani's vivid memory of the day that she was dropped off at the school by her mother, and her description of being dropped off outside this large brick prison-like institution, and being left totally alone as a little girl of 10 or 11. It was just so stark. And then when it became clear that, in fact, no proper evaluation of her had in fact been conducted, That helped us to make out that part of the case. And the third thing that helped make out that part of the case was was the link between being placed in that institution and being sexually sterilized. Because the fact was that if you were a girl approaching puberty in the Provincial Training School in the 1950s, you were going to be sterilized. It was like an inevitable consequence of being placed there. The legislation it was the exact opposite of what the legislation said. The legislation said you should only be sterilized if you're going to be released from the institution, not placed in it. But the fact was that if you were, if you fell into that, within that description, as Leilani did, you know, a girl approaching puberty, you know, being placed in this institution, she was going to be sent to the Eugenics board, and they were going to, with a 99.9% certainty, direct that she be sterilized. And because she was in that institution, at the institution's discretion, you knew that that sterilization order was going to be carried out. You know, there wasn't a prospect of her, you know, being released from there before it could be carried out. You knew it was going to happen. And in her case, you had this horrendous circumstance where it appeared almost on the eve of her having been recommended to go to the Eugenics board by the institution director. Somebody realized, oh, we've never done any testing of her. We'd better do some testing. And they conducted this, you know, hurried examination, which the government's own lawyers acknowledged, you know, in the trial was completely inadequate for, you know, for the kind of decision they were going to make. So when you tie that circumstance to, you know, this is what happens when you are admitted into this institution. This is one of the consequences of being confined here. That really helped to demonstrate, you know, the severe impact of this completely casual approach to admitting her there. And so it was possible for us to make out the case that she had, in fact, been wrongly confined in that institution for, you know, most of her, you know, from before her adolescence, you know, until her late teenage years. There were, in the cases that followed, where we and other lawyers represented a very wide range of claimants who had very widely different capabilities, and some of whom did have developmental disabilities, some of them severe. That claim was not one that you could make out with any degree of certainty, because given the times, given the legislation, the reality of institutional care was one that had to be accepted. One of the things that struck me about from the subsequent cases that we handled after Leilani's, I'm thinking of one pair of cases in particular. Two sisters who had been brought up in this extraordinarily deprived setting in northern Alberta, and both of whom I met when they were in their 50s. And neither of whom I would have ever imagined would have been subjected to that kind of treatment. And then as we went into into their case files, and we started to see the description of the extreme poverty in which they had been raised, and the extraordinarily deprived circumstances that their family had lived in, and there seemed to be significant elements of neglect. I remember discussing this with one of the experts who we had retained, a psychologist who had actually worked within the Alberta mental health system for many years and had gone on to become an internationally acknowledged expert in child development. And I remember showing him those case files, and he looked at them and he said, you know, we write about these things all the time. We write about, you know, how deprivation and so forth can lead to, you know, people appearing to be less able than they are. And he said, but he said, this is the clearest example I have ever seen of that. He said, this is like, you know, I've written the textbook and now I found, you know, here is the clearest evidence of you know what I've been writing about for so many years. And that the lack of awareness of that, and the fact that people would be treated as what was called defective because they had been raised in poor circumstances was one of the things that just I found just shocking.
Mm-hmm.
There were things that we discovered. Some things came out in Leilani's trial, and then, you know, we heard so much more about them from other people. The way in which discipline was enforced in this institution by taking children who were called higher functioning, and if they were thought to have been misbehaved, putting them in wards with people who were severely disabled and who would have been frightening to a child was something which was, you know, again, just completely shocking. So I mean, there were hundreds of people, you know, who we talked to after Leilani, and all of them had, you know, there was a human story about everybody that we talked to. There were very wide range of circumstances, but it was the gratifying thing about it was talking to people, you know, and being able to give them this opportunity to be treated, you know, as fully human, which they had been denied before. Whatever we see next will be more sophisticated. It will be based on a more developed sense of the science of you know, of what causes various traits to be transmitted from one generation to the next. The eugenics legislation of the 1920s was based on what was thought to be the leading science of the day, and that it was reflecting scientific principles, and it was converting them into legislation, and that it was progressive, and it attracted support from surprising quarters for, you know, on the basis that it was progressive. Do I think that we're not going to fall into that same trap again? Of course we're going to fall into that same trap again. We believe we know more now. We believe we can be sure about predicting what will happen and who it will happen to, and we're always prepared to make, you know, policy decisions based on what we think the best science is, and inevitably, you know, we're going to do something. We're going to do something wrong again. People get targeted in two different ways. They get targeted by governments, and then they get targeted by other people. I mean, there are concerns that there are certain cultures in which people are targeted on the basis of their gender before they're born. Whether or when governments will do it, because that's really what we're talking about. We're talking about when governments start to target people. Whether or when that will happen is hard to predict, but the desire to look for a scapegoat, the desire to address a social problem, you know, or appear to be addressing a social problem by, you know, adopting some scientific, so-called scientific approach is, I think, pretty well always irresistible. Who will be the targets? It's hard to know. If instead of Leilani we had been approached by somebody who had a significant developmental disability who asked us to bring the case, I think that we would have been able to succeed with the claim for being wrongfully sterilized because what we discovered in the course of the lawsuit was the pervasive lack of regard by the government and the Eugenics Board to the legislation they were supposed to be enforcing. We saw this pervasive kind of lawless behavior on the part of the Eugenics Board, which really meant that their decision could not be, you know, justified or upheld in any of the cases that they dealt with. There would have been parts of the claim that we would have had more difficulty in making out. As I said, in the case of people who had significant developmental disabilities, the case for wrongful confinement would have been a much tougher sell. We weren't successful in Leilani's case in ultimately making out a significant claim for loss of ability to earn income, and that would have been the case as well with somebody who had a severe developmental disability. So, I think the case would have been made out. The response would have been different in some ways because one of Leilani's great strengths is her ability to be a spokesperson, and that may or may not have been possible with somebody who had a developmental disability. It's certainly not impossible, but that's a particular strength of Leilani's that I think has affected the public view of her case. So I think the case could have been made out, but how it was perceived by the public might have been a little different.